Hello students, today we are going to understand the beginning and growth of medico-legal work across the civilization. Legal provisions controlling medical practice existed in ancient Egypt. Improper treatment and causing death of patients were punished. Egyptians were famous for artificial preservation of dead bodies by mummification. The works of Homer Diodorus are ancient literatures containing medico-legal matters. The Papyrus of ancient Egypt gives an account of sexual perversion, marriage customs, and diagnosis of poisoning. All these date back to about 3000 BC. Imhotep, a celebrated man of this period, was the Grand Vizier, Chief Justice, and physician to King Zoser of Egypt. He was the first man to combine the science of law and medicine and is considered by many as the first medico-legal expert. The first law code of Babylon was written by King Hammurabi in 2200 BC, which prescribed laws regulating medical practice and punishments for civil and criminal liabilities of physicians, adultery, rape, incest, and violent deaths. Sir Sidney Smith, a contemporary of Sir Bernard Salisbury, having studied in Edinburgh, came to Egypt and pioneered the scientific investigation of crime in Egypt. He also wrote a textbook on forensic medicine and edited Taylor's Principle and Practice of Medical Jurisprudence. In Persia, medical practice was regulated, malpractice and criminal abortions were punished, injuries were classified, and injured persons were examined. In Rome, Numa Pompilius (600 BC) made a provision to open the body of a woman immediately after death during confinement. An article of Lex Equulia deals with lethality of wounds and expert medical opinion in assessing their gravity. In 12th table of 449 BC, a period of 300 days was set for the duration of pregnancy and birth to take place within 10 months. Incapacity of the insane was recognized and disposal of dead controlled. Lex Cornelia of Sulla (138–278 BC) provides that 5 midwives should prove the pregnancy. Inducing abortion, administration, and a physician causing death of his patient were heavily punished. When Julius Caesar was murdered, a, his body was examined by Antistius, a physician. He opined that one of 23 wounds was only fatal, and he is another person who is considered by many of the first medical legal experts. The place of the physician in courts and legal matters as expert witness has been clearly shown under the rule of Emperor Justinian. Under the Justinian Code, considered the earliest medical code in ancient Europe, to define the role of medico-legal experts in dealing with the medico-legal problems, physicians were supposed to prove pregnancy, time of delivery, sterility, impotency, rape, poisoning, and mental illness. In the digest, it has been remarked, physicians are not ordinary witnesses, but they give judgment rather than testimonies, thus recognizing the special status of expert witness, of expertise, and implying the establishment and the medico-legist was impartial advocate. Ancient Greece, In Greece, the contribution by Hippocrates to modern medicine is most outstanding. Besides other things, the Hippocratic Oath as a part of medical law and ethics continues to occupy its place in medicine. Aristotle, 1384 to 322 BC, fixed the animation of the fetus at the 40th day and advocated abortion for population control. Archimedes, 287 to 212 BC, laid the first foundation of forensic science by detecting gold adulteration in the crown of the king of Cyrus. In Italy, Roger II of Sicily in 1140 AD brought medical practice under law, and in 1224 AD Frederick II ordained public examination of physicians based on the teaching of Hippocrates. Rules were framed for the admission, teaching and training of physicians. Dissection of human body in public every 5 years was ordered. From the end of the 13th century, medico-legal work of different kinds as well as autopsies were conducted by doctors. The first medico-legal autopsy was done by Bartholomew in Bologna in 1302. Thus, it is clear that legal medicine first emerged out as a separate entity in Italy. In France, the Bishop of Maine and Angers are said to have medical experts in their service from the 11th century. From 1260 AD, provisions were made for medical experts and surgeons and physicians were sworn to give advice evidence in court. The right of autopsy was given to the faculty of Montepellier by the Pope in 1374 AD. In about 1250 AD, a book Sai Hyon Lu, or approximately Instructions to Coroners, was published in China, which deals with medico-legal matters, inquests, criminal abortions, infanticides, signs of death, assaults, suicides, asphyxial deaths, and poisoning. A systematized law code was prepared in 1507, providing medical evidence in violent death. Accordingly, cases of personal injuries, murder, infanticide, abortions were being investigated. Courts were compelled to call for medical evidence in certain cases. In Great Britain, Samuel Ford wrote the first systematic book on medical jurisprudence in English, which was published in London in 1788. The first British teacher of legal medicine was Andrew Duncan, Senior. He started courses of lectures on legal medicine at the University of Edinburgh in 1789 and wrote a book on legal medicine in 1792. Due to his untiring efforts, a chair was established at the University of Edinburgh in 1807, and his son Andrew Duncan Jr. was the first incumbent. The development of legal medicine in America took place much later and suffered many setbacks. The British colonization introduced the coroner system in the 17th century. Perhaps the earliest autopsy on record was done in 17th century in North America. The coroner system was replaced by medical examiner system in 1807 in Boston. in 1915 in New York, and then in other parts of the America. Until the start of the 19th century, nothing had been written on legal medicine in the United States. This is all for today. Thank you so much.